this presentation so that anyone can reference it if you want to at a later time, and then people who are unable to attend, we can share with them as well. I'm going to speak for just a couple minutes, introduce everyone, and then we'll get things started with our program. So it's great to see you all here. Welcome to our webinar on contract basics for small businesses. As we all know, running a small business or being an entrepreneur or even thinking about starting a small business requires a very good understanding of contract law. There are a lot of things that we do as small business owners, whether it's working with employees or independent contractors inside the business, or if we're contracting with third parties, people who we want to sell our product, or people we want to have a joint collaboration with, where contracts are critical. Just getting the information about our agreement or arrangements in writing is essential to protect ourselves from liability. So we're really excited to present this webinar that will get into some of the details about how you can use contracts to improve your business. As I'm going to introduce myself now, as I've met a lot of you, my name is Matt Kugazaki. I'm at England County's Legal Services. I'm the pro bono director here. Along with Kayla Henderson, we run the small business program here. And I imagine that most of you have met with one of us or both of us. And if you have not met us before, it's really, really great to meet you. And thank you for being here. And I'm really happy that this webinar topic brought you to us. This is a webinar that we have as part of a webinar series. You've probably seen information and you will see about the other webinars that we're hosting over the summer. In addition to that, ICLS, we are a nonprofit organization that provides free legal services to those with limited means in Riverside and San Bernardino counties. This program specifically is brought by our small business clinic. And our small business clinic's mission is to provide free legal services to business owners and entrepreneurs in a whole range of areas, from contract law, entity formation, trademark, employment, in tax, real estate, any area essentially that will help you run your business. We have some eligibility requirements because we are a publicly funded nonprofit. And we offer not only these webinars, but also one-on-one individual consultations with volunteer attorneys. So if you're interested in learning more, please feel free to reach out to either Kayla or me. You should have our information, but we will send you all a thank you at the end, in a couple days with the recording of the webinar. So you should all feel free to reach out to us if you have any questions. All right, now let's get started. So during today's webinar, please feel free to ask questions. We want this to be interactive. We want you to ask questions. So if you have questions along the way, please feel free to add them to the chat. Kayla and I will be monitoring them, and there will be time for questions throughout the webinar and especially at the end of the webinar. Our presenters here today are from the law firm of Simpson Thacher. We have Jesse Fang, Jacob Gint, Marielle McClenahan, Christian Sheets, and Mark Natividad, who is here today. And they are attorneys at Simpson Thacher who help businesses thrive. Simpson Thacher is one of the largest law firms in the world. They have over 1,000 attorneys in 11 different offices worldwide. They are known as one of the best law firms in the nation in many, 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 many areas. Many of the world's leading companies, from finance to philanthropy, from Fortune 500 companies to high-tech startups, come to Simpson Thacher for trusted counsel. We are providing this webinar through their pro bono program, and we are very, very excited to have Nadine Monpremier, who is also here, who is on Simpson Thacher's pro bono team, which is the team that helps divert their legal services to help the community, including as part of the small business clinic. With all that, I'm gonna hand it over to our presenters now, and I'm sure they'll introduce themselves a little bit more. And thank you everyone for being here.
Great, thanks, Matt. As Matt said, we're from the Simpson Thacher office out here in Palo Alto, California, and we're here today to present some contract basics as they apply to small businesses. Before we get started, we have to read, of course, as lawyers, a little disclaimer that the contents of this presentation are for informational purposes only. None of Inland County Legal Services, Simpson Thacher Bartlett, or the attorneys, employees, or volunteers making this presentation are rendering legal or other professional advice or opinions on specific facts or matters The viewing and or distribution of this presentation to any person that does not constitute the establishment of an attorney-client or other relationship, and we do not assume any liability in connection with its use. With that out of the way, I think we can just go straight to the overview, which will provide you a roadmap of today's presentation. Once again, my name is Jesse Fang. I am a senior associate here at Simpson Thacher, along with my colleagues Marielle McClanahan, Christian Sheets, and Mark Natividad. And we are excited to give you this contract. Slide, please. Contract presentation. We will start off with basics, which will briefly discuss the key legal theories in contract law, and that may help you set the stage for contract negotiation and drafting. Then we'll move on to key provisions that appear in everyday contracts so that you can understand and help create better contracts. We'll review IP provisions and how IP rights may interplay with your business and your contract drafting or negotiation. We'll go over best practices and things to keep in mind as you approach contracts. And then we'll open up the presentation for a general Q&A. As Matt said, throughout the presentation, if you have any questions before we move on to the next slide, feel free to send them to the chat or raise your hand, unmute, whatever. We're happy to discuss hypotheticals or questions that you have going through as we go through the slides. All right. Slide, please. So this is just kind of a background of what Simpson Thacher does in terms of pro bono to small businesses. We generally help on a limited scope nature. And what that means is through service providers like Inland County Legal Services and others throughout the nation, we provide one-on-one consultations to entrepreneurs. And we help with things such as entity selection. If you're looking at creating a limited liability entity by which you want to expand or just give your business. We also provide contract and commercial lease review and negotiation review. We help draft corporate documents if you decide that you want to create an LLC or a corporation or other types of entities. And we also provide ongoing corporate governance review if you already have an entity set up. Like I said, generally these services are through limited scope sessions, which means we will meet with the entrepreneur during a single 1-hour session and then provide advice at that session. And then if applicable, follow up with a revised contract or suggestions to your contract or corporate documents. Sometimes STB's pro bono program can take on clients in a full scope representation. And for more information on that, we ask that you reach out to either Inland County Legal Services, and they might be able to create that discussion with our pro bono department. Slide, please. All right, so while this is we've already talked about this. Next slide. Okay, so now we'll start with the contract basics, and we'll start with the black letter law of what a contract is, just to kind of give you guys an idea of what we are talking about from a legal perspective. So a contract simply is just an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable at law. We want you to take a moment and just kind of realize how broad that legal definition is. When we hear contracts, we think of detailed written agreements, but really contracts encompass so much more, right? They can be verbal contracts, but we highly recommend that your contract is always in writing. But sometimes a simple oral argument is all that's needed to create an enforceable contract at law. In the background, I guess for there to be a contract, there's got to be mutual assent, and this is kind of a legal term. We'll break this down and then go into like what it means in day to day. Basically, mutual assent is the idea that one party makes an offer, and then the other party accepts it, and that there was consideration. And consideration means that there's something of value that was exchanged. So, for example, at like the very basics, if you want to say like a grocery store offers to sell a dozen eggs for $4, the patron accepts that offer by giving $4 to the cashier, and the $4 for the eggs was the consideration. Another example might be if a counselor is offering services to a client to improve their health according to like a customized package with an initial payment of, let's say, $150, and then bi-weekly payments of $300 for achieving, I don't know, X condition on week 1, Y condition on week 2, etc. The client would accept this offer by signing the contract and paying the initial payment. One more example, if there's a contractor offering to build according to a schedule in the agreement, you can have, stage 1 would be demo, stage 2 site prep, stage 3 rough work, stage 4 finish work. And the patron would accept this offer by paying the down payment and for signing the contract. The important thing to note here is that there is exchange. So if you promise to do something and the other party does not have, the important thing to note is that there has to be exchange of consideration. So if you promise to do something and the other party doesn't have to perform anything at all, that's not a contract, that's just a gift. And so there's nothing really enforceable by law. Okay, next slide. So we've asked, we've mentioned that contracts don't always have to be in writing, but there are some contracts that have to be in writing, and every state, including the U.S., within the U.S., except for Louisiana, has adopted laws that are basically known as the statute of frauds. And so these are contracts that must be in writing. Otherwise, there was no contract; it just does not exist. The things here we want to know for your consideration are services for over $500 and contracts for sales of goods for over $500 and contracts that are over a year. In order for these to be enforceable by a court of law, they have to be written down. Regardless of whether or not your contract needs to be written down in order to satisfy the statute of frauds, we highly recommend that it's best practices to always create a written contract with both parties signing, and to be sure to keep a copy of it. Whether it's you make a copy at a FedEx or just even take photos of it, so that's in your own phone, just so both parties have a copy of that contract. Other things that a contract generally satisfies written requirements, right? If it identifies both parties and includes essential terms. And the last portion, the clear intention by both parties into the contract, is usually evidenced by signing. Again, we want to emphasize like the contract itself is a very simple document at heart, but oftentimes becomes much more complicated. But those are really the basic requirements that are needed. Slide, please.
Real quick, we do have a question in the chat that I think
Sure, yeah.
The slide about contract execution. Kathy Lozano asks, what if the contract is never executed, such that neither party signs, but the contract is, presented, right? But maybe one or both of the parties do not sign.
Yeah, so at that point, there is no contract, right? That's more, if you go back to the initial terminology, that's an offer, but then there's been no acceptance at that stage. There are limited exceptions where the offer is made and both parties start performing. That gets kind of nuanced, right? Because while there is no signature on that contract, you've got both parties performing parts of the contract. Technically speaking, like that, at that point, it's best to just make sure that the contract is signed.
Right. I'll also add that there is a danger that there could also, or maybe not a danger, but a risk, or that there is an oral contract that is happening as well. Because a lot of times people will say a lot of things during contract negotiations, and the presenters are saying that there could be an oral contract. That is a real contract that you could be on the hook for. And it's really, really hard to know what the terms are because you never wrote them down, which is why people like having written contracts. So a lot of times the written contract will then replace the oral agreement, But if you never have that written contract signed, then there's a risk that that oral contract may also be going on. So it's something to consider. If you have like a contract that's unsigned, what are the reasons for that? Is the person that you're opposed to not signing it because they'd rather just operate the way that you've been kind of doing? And if that's the case, then you may have a separate written or oral contract. But that's why it's important to always have written contracts signed, because that's what's, then everyone knows what's going on. And there is a related question, that is, if payment is submitted and services are rendered, does the payment execute the contract? I'll just say that there are a lot of factors that will determine whether or not a contract is executed. Essentially, it's if the parties intend for that payment to effectuate the contract, then it could very well be effectuated by that. But you would have to look at the terms and everything else. And I'm wondering, I'm sorry, but if you have other things to add to that question, please do.
No, I think what you said, Matt, is right on the money.
All right. Thank you for the questions, Kathy. If you have more, or if anyone has questions, please keep them coming.
Great. So, all right. So, there's a ton of other items to go through, but another basic portion of the contract, right? We've just briefly touched on offer acceptance and the signing of the contract. We'll talk about breach briefly as well. And the breach of contract is simply if one or more parties fail to meet the obligations under the contract. This typically occurs at the time of performance or delivery of the exchange. So think about the examples previously mentioned, right? So if a patron doesn't pay for those eggs, the patron is breached. If the counselor's advice fails to produce X results that they promised, the counselor has breached. If the contractor has finished stage 1 of the contract, but the customer has failed to pay for stage 1, then the customer is in breach. There are several defenses to a breach, and we'll just talk about the top 4 or 5 of them that we think are relevant, although there are many other examples of defenses to breach. So one example is impossibility to perform. And what happens with impossibility is something that we saw during the COVID pandemic, right? There was an instance where the nation just closed down and stores were shut down, or people just weren't going to work because the government told us all to shelter in place. That was something that could not have been foreseen. And so that is a defense to a breach of a contract, right? Like if you literally could not go to work because the government didn't allow you to go, then there was no way you could have performed your end of that contract. As we mentioned prior, the statute of frauds, right? If the statute of frauds requires that your contract be written down in order to be a valid contract, then not having a written contract would mean that you have not breached that contract. So for instance, if I promise to sell someone a plot of land, well, according to California statute of frauds, that has to be written down. And so if that wasn't written down and signed, generally speaking, then there was no contract formed. Lack of authority or capacity to contract. If you are not of sound mind at the time, or by usually that's by decision of court or by law, or you are contracting with a minor who is not over 18, they do not have the authority to bind your business or the ability to make decisions. So that is a defense to breaching a contract. If the contract is so indefinite or uncertain that the terms just can't be determined, it's so vague, it doesn't make sense. It's more like, you read the contract and it sounds more like it's just like a launching pad for idea creation. That'll be a defense to a breach of contract as well. And finally, waiver. If someone is breaching a contract or is in breach, but the other party waives it and just allows that breach to occur, then you are no longer in breach of that contract, and it's that breach has been excused. Slide, please.
Before we move on, we do have another question from Stacey.
Sure.
It's a question where she said there was no written contract or no contract. And she received a check to complete services that were, I guess, agreed on, but without a contract. But then the other side changed their mind. But with that check, contractors were paid, some work was done. And the question is, was that, do they have to return the check? Was that an enforceable contract? Was that, what is the situation there?
I would ask for more information. It depends on the type of contract that was signed and whether or not it technically needed to be under the statute of frauds. It sounds like it may not have been, but if it's goods or services over $500, technically it needs to be a written contract. I think there's another portion we can talk about in the breaches and the issues here that may be a more practical remedy rather than like thinking about this in a legal standpoint. And I'll just go over that now very quickly. So basically, so there's legal remedies for a breach of contract, right? And you'd have to go through the courts of law for that, go through small claims or I forget what the limit is, but if it's over that limit, then you might have to go to the Superior Court of California. The other option is really just the business option for remedies. And what I mean by that is sometimes it's just from a business perspective, the idea is that you just want to get work done. You want folks to leave on a happy note, right? So there might be a compromise to be made there to kind of figure out what was going on. Whether or not you decide to take the business approach to cure a breach of contract or take the legal remedy is just really a business decision. And sometimes what that means is opening the door to negotiating with the other party to make sure both people leave satisfied.
Great. I'll just reiterate with Stacy your question too.
Sure.
What Jesse was saying, that there's probably a lot of facts. You'd really have to look at the whole contract because and I guess there is no contract here, but you may even have to look at if you had discussions with the other side about what you were planning to do and all that, and to really understand whether or not, what are the obligations related to it. There's never one simple question with one or two sentences. All right. Are we moving on, Jeff, next?
Yeah, we can move on.
Great. So next, we just want to go over some factors to consider when you're entering into an agreement. The first is just overall the purpose of the agreement. Is this, to enter into an agreement to provide services? Is this an employment agreement? Are you entering into some sort of partnership? You want to make sure that overall the agreement actually achieves the goals that you set out to intend at the outset. And you also want to consider the source of the agreement. Is this a type of agreement that you and or the counterparty regularly enter into and you're very comfortable and experienced with this kind of agreement or not? Your bargaining power, is this a situation where you can kind of present the terms and not have much negotiation? Or is there going to be, more back and forth involved? Again, if it's an oral contract, you have to consider whether it actually needs to be written down in order to be legally enforceable. And even if not, if it's the kind of contract that you would prefer to have in writing, just so you and the other party clearly understand what the terms are and you don't have to get into these kinds of disputes that we were kind of discussing. Also, where the agreement comes from. Is this the counterparty's agreement? In that case, it might be more favorable to them, and you just want to make sure you're really carefully understanding what those terms are. Or, it's possible to kind of create your own. There are a lot of forms that you could find online that you could adapt and make your own. But in those situations, you just want to make sure you do, again, carefully read through the full agreement and actually understand everything that's in there is what you need and nothing that you don't, and that you actually understand everything. And finally, we talked about this a little bit already, but, if you're having discussions about what you want the agreement to say, make sure that's actually what it says. If, the counterparty is saying, for example, that they're going to supply certain parts to you and that if they're broken, no problem, they're going to guarantee they can fix it without any cost to you. Maybe they said that in negotiations, but is that actually what the contract says, for example? So I think we can go to the next slide. Again, the contract type. So are you going to be providing consulting services? Are you going to be selling baked goods? Are you going to be starting a limited liability company and you want to write an agreement that dictates how that company is going to be run. And another big one that kind of ties into everything is the governing law. This is going to impact how certain provisions are interpreted, or if maybe you have to go to court one day where you have to do that could come into play. And so, especially if you're using a counterparties form or finding something online, make sure that the governing law is something that is actually favorable to you, or, if it says that it's going to have to be, you'd have to go to court in Delaware, for example, if both parties are in California, is that something that you really want to actually do? Also, if you want to change the agreement, hopefully at the outset, everything you agree is crystal clear and you don't have to make any changes. But of course, things change all the time. So it might be good at the outset to come to an agreement on how you would change any of the terms. Maybe you just want to say that it's by mutual written consent so that, going forward, you would again continue to write amendments and changes to that same contract. And then finally, just make sure that just because you legally can do something, you want to make sure that it makes business sense also to do it. So for example, if you run a bakery and you're saying that you won't take any cancellations under any circumstances, maybe you have the right to do that, but maybe there's a bakery down the street that allows more flexibility, and will that impact your business at all? We can go to the next slide. So this is just a summary of the things that I just went over. Just make sure you are, just make sure the agreement overall is what you actually, achieving the goal that you actually want to achieve in the first place. Know where the contract came from and that you understand all the terms in it. If circumstances change, make sure you and the counterparty understand how you're going to adapt to those changes, and that ultimately it makes sense for your business. We can go to the next slide.
Okay, so now we're going to kind of go deeper into the contracts and kind of flag some key provisions that are in the contracts. So first off, like pretty basic, who's signing the contracts? What are the parties? And one thing to flag is if you have a business name, a business entity, that should be who's signing the contract. Like you can sign as your individual in your role as officer or owner as the business, but the business should be the one that's entering into a contract. And this is especially important if you've already formed an LLC or a corporation, but that kind of opens another can of worms. But just know that you should be signing in the name of the business. The next is kind of what is the purpose of the contract? What are you trying to do here? The description of goods and services should be pretty clear. And this calls to mind for me an example from law school, and I won't bore you with the case law, but it was a case that hinged on what was the definition of chicken, because the contract said, I'll supply X pounds of chicken. And one guy thought this meant, some type of chicken, like chicken breasts, and another person thought chicken thighs. And so that's kind of like a silly example, but if you want chicken thighs, you want to make it clear that that's what I want. Price, so the price could be fixed or variable. So calling back to Jesse's example on the eggs, you could have something where, you have a dozen eggs for $4, but if you buy 2 dozen eggs, then each dozen costs $3.50 or something like that. So that would be a variable price. If the more you buy, the less the cost per item is. That's just one example of how it could be fixed versus variable. Commission or salary, you could hire an employee that gets paid for a percentage of the sales they do versus, a salary or a combination of both. And then the term, how long is the contract going to be? Is it going to be a contract that is for a month? Is it going to be a year? And the other thing to flag here is the automatic renewal. So you could enter into a contract that you'd think, was only going to be for a year, but if there's a clause that says the contract's going to automatically renew, that contract might just keep going, and you might not realize that when you sign it. So you should always make sure that you know what the term is, whether or not it's going to be renewed, and if you have the right to not renew, certain things. So just when you see that automatic renewal, you want to flag that in your mind.
And continuing on the idea of termination and renewal, you want to think about, how does the agreement end? Is there just a fixed term and it lasts for 1 year and then it terminates? Or is it something that, will automatically renew unless both parties actually agree to terminate the agreement? Do you have to provide some sort of notice before you terminate the agreement? Maybe you want 30 days notice, for example. And also maybe the agreement continues automatically, but you want to be able to provide notice for any reason that you want to terminate the agreement. Maybe both parties can just at any time say that they want to terminate it, or maybe you want to only provide specific reasons to terminate the agreement. Maybe you can only terminate because there's been a breach, for example. And even in that circumstance, how much notice do you want to give to the other party before the agreement's over? And you also might want to think about any provisions that you want to survive even if the rest of the agreement ends. So one might be indemnification if the counterparty has agreed to protect you from certain losses. Maybe if you kind of find out about those losses later, you want that to continue beyond the end of the agreement. Or maybe there's some sort of confidential information that's been disclosed. Maybe you want those confidentiality obligations to continue even longer than the main agreement. Another key provision is force majeure. So we talked about this a little bit, but of course, we've all lived through a global pandemic. We know that sometimes things that are beyond our control can impact our ability to fulfill our obligations under an agreement. And so you could put a provision in there that says, if one of these kind of major natural events or a war or other kind of big disaster happens that's going to impact our ability to perform, then that's excused and you won't be liable for not performing under the agreement. You could make this extremely broad, or you could make it more narrow. Maybe you only put specific events that could happen that apply under this provision. And you could determine whether it automatically terminates the agreement or if it's only suspended for a certain period of time. And again, if you want to provide some sort of notice, even when this sort of thing happens before the agreement's over. And if you want both parties to at least try to give a good faith effort to fulfill their obligations, despite some sort of event outside of their control that is negatively impacting their ability to do so.
One thing before we move to the next slide on termination and renewal is, and contracts generally, is that contracts are really open to how you want to negotiate with the other party. So something to think about, like if there is a termination provision in there, you might want to consider, okay, it's a year-long contract. If you decide to terminate, 6 months into it, you have to pay some sort of termination fee or like a make whole type of fee, and that's something that can absolutely be contracted in. What comes to mind is services contracts where let's say that it's a catering business and you cater out a year in advance. If someone were to cancel on you like 2 months before, that might create a hole in your pocket or something where you can't get another gig in 2 months. So there might be a termination fee versus if they wanted to terminate the day after they sign. So you still have 11 months and 29 days. At that point, maybe the termination is just without, maybe they just forfeit their deposit. So that's something to keep in mind with regards to termination provisions. Going on to the next slide, we talked about notice. One thing we recommend with notice provisions is that you should always make sure that notices are in writing. You can specify what kind of writing. So whether it's by certified mail, regular mail, email, text messages, it's really up to what you want to write as what constitute proper notice. Consider also whether notice is deemed given upon receipt or given after X amount of days. This kind of gets into the nuances of things, but what really matters on notice is whether or not you actually receive notice. Right. So like, what if you sent something, but the other party never received it? Or conversely, what if someone sent you notice for cancellation, but you never received it? Right. So we want to make sure that the notice provision is accurate into you and your party's understandings. So depending on the context or the importance of notice, we usually recommend that parties use certified mail or mail with tracking, just so you know that there's proof of notice or proof of something being delivered. Lastly, you should always ensure that your notice address or contact information is correct in the actual agreement before you sign. A default is essentially a breach of the contract. But from a business perspective, most folks aren't in the business of intentionally defaulting on the contract. They worked hard to negotiate and draft. So usually, rather than just automatically defaulting and relying on the court of law to kind of right a wrong or an injury, most people tend to pre-negotiate a grace period to fix the situation. So a default would technically have like a cure period. So usually we see a default maybe with a cure period of about like 15 days or 15 business days or a month, depending on how long your contract might be for. Another thing to note is that typically the notice of default is what starts the grace period or that time period. So that form of notice usually is that written notice to the other party saying, hey, like we think you're under default of our agreement. You know, pursuant to our agreement, you're hereby notified of a default under what provision and whatnot. And so that's really what we see when there's a default and cure in these provisions. Lastly, we'll talk about the limitation of liability. So a limitation of liability provides caps on damages by limiting the amount of money that one party can recover from the other party due to breaches in the contract. For example, for service providers, you can sometimes limit the liability to no more than what was charged for the services under the agreement. You can also draft this in a way where, let's say you have several stages of the agreement. So like going back to the contractor example, rather than just saying, hey, stage 1, 2, 3, and 4 in the contract, you might be able to say, the contractor agrees to provide X services pursuant to the statements of work that are attached to the contract. And then in your limitations of liability section, you can say your limitations of liability are limited to the scope of work being performed under whatever statement of work. So that way you can kind of potentially, cabinet your liability exposure there. Of course, that being said, the other party would have to agree to that, and they may decide, hey, no, like your liability should be for the whole contract, and that becomes potentially a point of negotiation. One key consideration on the limitations of liability is that courts generally say that they're only enforceable if both parties can freely negotiate it and understand it. So you can't bury this limitation of liability section within the contract. We generally recommend that it's its own section, its own paragraph in bold and in caps. Slide, please.
So Mari kind of touched on indemnification earlier. It's basically a requirement for one party to bear kind of the liability or cost of another party. So if I, contract to sell you food for your restaurant and I agree to, indemnify you of any liability, if people get sick at your restaurant, it's because of my food, I might have to pay all the costs that you have to pay from that. And you could also have a provision that says you're agreeing to hold someone harmless, and it's in that example at least kind of like the flip side. Like if you agreed to hold me harmless about my food, if people got sick from what I supplied you, then I wouldn't have any liability to you. And then no waiver is a provision that's would be put in, and it's intended to prevent the waiving of the whole contract if you waive a certain part of the contract. So we talked about earlier waiving breach and how that's a defense to breach. And so if someone breaches your contract and you waive it, a no waiver provision is in there to prevent them coming back and saying, oh, you waived the whole contract, or you waived this provision of the contract, instead of just, oh no, you just waived that one part. So it'll say something like any waiver of the breach would not waive the whole contract, something like that. And then I guess down here it just says that no waiver, any waiver must be in writing and signed usually.
And another thing to consider is If there is a dispute under the contract, how is that going to get resolved? So, maybe you go to small claims court, or maybe it would be faster and maybe a little cheaper if you were to go through mediation or arbitration instead. And I touched on this a little bit earlier, but where you would have to go to court if there is a dispute, you want to make sure it's actually somewhere that it would be convenient for both of the parties to go to, especially if you're using a form online. Maybe they're saying that you would use a venue in a different state. Another thing is if there's anything that needs to be completed or done before the agreement actually becomes effective. So, for example, if you are purchasing a large piece of equipment for your business, but you want to, take out a loan in order to do so, maybe you're trying to get it all kind of organized at the same time, you might say in the agreement to buy the new piece of equipment that it doesn't become effective until you have guaranteed that your loan is approved, for example. And we did touch on this also earlier, but just you want to make sure that the agreement that you're signing represents the entire agreement of the parties. And so any other negotiations or discussions that you've been having, written or oral, are going to be superseded by this agreement that you're signing.
Slide, please. Next slide. Thank you. Actually, sorry, one slide back. Thank you. There's a delay, isn't there? Sorry, one slide. We'll discuss confidentiality now and non-disclosure agreements. So I think that's one slide forward. Perfect. Yeah, thank you. So sometimes, if there's sensitive information being shared pursuant to a contract, let's say there's a service agreement where someone's going to design your website, and there's certain information that is behind a login, and you have to populate that information. That will there's always certainly going to be a confidentiality provision in the contract, or perhaps even an NDA. What's important to note here is that if there is any information that is carefully defined, and that you understand what the terms are for keeping that information confidential and not released elsewhere. Some things to keep in mind are how far the confidentiality provision extends. So is it only for you as the contracting as a CEO, or is it your business and your business's affiliates? Let's say you want to subcontract. It's important to understand just how those provisions have to be followed. Other times, you might have an NDA sent to you, and that's basically a confidentiality agreement between you and the contracting party. Again, the important thing to remember about NDAs is that you understand what the scope of information is that the company considers confidential, the period by which you have to keep all this information confidential and not share it, and also the provisions that I guess show you what information is not confidential, just so you understand what the other party expects you to keep protected. And again, last thing to know about the NDA is that there sometimes, usually there should be a tail end. So what we mean by that is that you don't want the NDA or the confidentiality provisions to extend forever. Usually, in the commercial sense, we typically see about a 3-year period, 1 to 3 year period, depending on the nature of the business and the contract of between the parties.
Yeah. Okay, so we're going to talk about intellectual property now. So intellectual property is pretty much intangible assets. It's not something that it could be in the form of a book, it could be in the form of something tangible, but the actual IP, right, that you own is in the idea itself. So this could include trade secrets, trademarks, copyrights, and patents. And so the way this comes into contract law is usually you're negotiating with someone on how to use your IP, or how they can use your IP, or how you can use theirs. And so the things about IP here is it's kind of hard to know. And it differs by each business on what IP you yourself want to protect, what IP you own, and what IP you need to be wary of that you're either using of others or might not understand that you're also actually potentially what's called infringing or using without someone else's permission. So if we go to the next slide has a lot of different it's a huge chart, basically giving you these 4 categories: copyright, trademark, patent, and trade secrets. And there's a lot of information here, but I'm just gonna walk through using a single example so you can compare the different kinds of IP that we have and see how it could apply to your business. I think of McDonald's as a very well-known business. And so if we take the first row of copyrights, we're thinking about artwork, creative works like pictures, videos, it could be commercials, any songs, as well as written works. So for McDonald's, I'm thinking of the website. So anything that they wrote and all the pictures they have on their website are going to be copyrighted, and they will have copyrights in that. And so that's same for your website. Anything that you've written, that you've typed, that you've taken pictures of yourself and you've put up, you have the copyright in that by law the moment you made it. It's not something that you have to register with the US Copyright Office, which is the national register here in the United States for you to be able to enforce your rights in copyright. It's just something that you already have by the moment you created it. The difference between copyright and trademark, which tend to get confused sometimes, is a trademark could be a picture like a logo or a brand, or it could be a word, or it could be a motto like "I'm loving it" with McDonald's. But what you want to think about is how can a consumer identify where this good or service is coming from and which location? And the way we do that for McDonald's is the golden M arch. As I said, the motto, "I'm loving it." So that golden M arch is technically a picture. So you have copyright in that too. But it's also a trademark because it's what's called the source indicator. So you basically can tell where and which business that service or good is coming from by the logo or by the slogan that you have attached to it. For patents, that tends to be a little bit more of what we think of as traditional intellectual property. But just to note that copyrights and trademarks, these are all still intellectual property. Patents are new inventions or new ways of doing something. So for McDonald's, that could be potentially a machine on how to cook the chicken nuggets, or a machine that learns how to cut the patties in a more specific diameter. But it can also be a utility patent, meaning, or a design patent, meaning the way it's designed actually helps do something new with it. And then finally, trade secrets are what they sound like they are. It's something that you have to kind of keep secret for it to be your property. And I'm thinking about the recipes that they use for their burgers, for their chicken nuggets, for their secret sauce or the McRib sauce that you have. The point of the trade secret is that your intellectual property in this is protected based on how well you keep it a secret. And so the 4 categories here, the main way I would really think about this is, how much do you really need to tell people about your ideas, your designs, your website, your brand, and how much can you keep that secret to the extent you can? My first line of, whenever I explain something in terms of intellectual property to a small business is, to the extent you can keep it a secret and makes sense to keep it a secret, you do. And then you only tell people like your employees after they've signed those confidentiality or NDA provisions, saying that they'll keep them secret. Because as much as someone can say something, they'll keep something secret. Once it's out there, you can't take it back. But the other thing, though, in terms of a trademark and a copyright, like your website and your logo, those are things that you do want to give out there in front of people and others, because they actually gain more power the more people know about them. And then that's how you get more protection for your own IP in terms of trademarks, because the more people know and associate your business with your mark or your logo or your slogan, then that way you'll have better protections in that. The best way to really get protection for a trademark is to register it with the United States Patent and Trademark Office, or the USPTO. This involves an application online that you can do where you submit your logo, whether it's just a specific word or the actual slogan or the actual picture of your brand. and then you type in your information, your business name, when you first used it in terms of commerce, meaning when you start selling things with it or when you start using it in your services. And then from there, the USPTO will make its decision within a few months that you can then use that mark, and only you can use that mark in that line of services throughout the entire country. So those are the different considerations here for intellectual property. Next slide, please. Okay, so again, focusing a little bit more on trademarks, because that's where we usually see small businesses really focus on their intellectual property. You want to make sure that before you choose a name, that no one else is using it in your line of services. Something that I think of here, for example, is Apple. Apple is already being used by the computer company. And the reason why I can use Apple, and even though it's a regular word, and register it as a trademark, is it's because it's distinctive in that category of services for computers and technology. If a fruit company wanted to call itself Apple, it probably wouldn't actually become registered as a trademark because it's too common to the average consumer that Apple company should not necessarily be able to own the word Apple for fruits when others would actually like to use the same word as well. And there's also the concept of likelihood of confusion. How likely is someone to be confused by an average consumer here, for example, in California, in the San Francisco Bay Area, using the name Apple for your new computer business versus the current existing one, Apple Inc. In Cupertino. So you want to think about what brands are already out there, how they're being used, where, and what line of services or goods they're being used for. And the best way to do that really is Google. The USPTO website does have a register of trademarks, but you honestly could just Google it and see how likely is someone to be confused by this. What we usually see is that the business already has its name and it's already started doing business in that. So the best way to really go about that is making sure that you're staying within your line of services and within your area, because you still already have, without registration of your trademark, protection in your specific field of business in your area, unless someone else came before you in that same area, in that same line of business, at which point they could potentially sue you so that they get priority rights to use their mark over you, in which point you might have to change yours. And finally, social media and website domains. These are common ways for people to just be able to register on Instagram or Twitter, or using an email address or a domain name like www.apple.com. You want to be able to register as many variations of your personal business name as you can, because otherwise someone else might take it from you and you'd have to buy it off of them. And the thing to consider there really is, again, make sure that the name you're using before you invest in it isn't being used by someone else already. Because once you invest in something and you start building your own reputation, your business reputation off that brand, it's kind of hard to take back and start over with a new brand if someone else had already owned it. And then you also want to make sure that it's something that you can control and can easily, I guess, manage, because otherwise it might be difficult for customers to find you or identify you with another business with a similar name, brand, logo, and the same set of services. So I think that's basically what we have for IP.
Yeah. One thing I'd like to note before we move on to the next slide is that, if you're thinking about creating a business or company, LLC, or a corporation, you don't have to necessarily trademark that name. You can always create that entity and you can do a business as type of registration where you're known as like Galaxy Inc. or Galaxy LLC, whatever it is. And then you can do business as by filing with your county the specific name you'd like to use that might be more catchy or intuitive for your line of business. And then to what Mark was saying too about the trademark idea is, even if you don't go through the trademark application process, as long as you realize, like, if you start using your name, you've already started establishing your trademark, and the state of California will give you protections within our state as well. So the trademark application process can be complicated because like many government entities and processes, it has to follow specific forms and requirements and notices from the government, which I think Inland County Services, Legal Services might provide help with that. And I know there's other firms around here that offer pro bono services with filing trademark rights as well. Okay, now I think we'll go over to the contract best practices when drafting, negotiating contracts.
Okay, so yeah, like Jesse said, we're just going to go over some best practices, some like general ideas of things to consider and things to think about. So these first three kind of go together in my mind. Be reasonable, you know, consider how much leverage you have. Like, are you contracting with Google, Apple? Are you contracting with another smaller business? Create a collaborative environment, because at the end of this contract, depending on what it is, you're probably going to be working with the other person at least for a little bit. So you don't want to have a hostile environment and then have to, you know, keep working with them for the term of, you know, the contract. And kind of going into that, don't take an all or nothing approach, but maybe consider things that are your must-haves or hard lines that you might not want to compromise as much on, or you know, don't want to compromise at all on, but maybe think of other things that you can compromise on. You know, it's a balance. You know, start with big picture items. It's easier if you have a general idea of what the contract's going to be before you start getting into the nitty gritty, and then, you know, maybe then take care of some easy items so you start on a good note, get things squared away. Keep your business goals in mind. I think we've kind of talked about that throughout the presentation. Like, make sure that you're meeting on the business side what you want to accomplish with the legal side. And be wary of unintentionally entering a contract. We've kind of talked about that. In the negotiations, you don't want to have accidentally created an oral contract or something like that. Next slide. And talking again about oral contracts, like we've harped on some examples here. It's better to have all contracts in writing, even if they don't have to be, just so, you know, everything's clear, all the terms are laid out, stuff like that, and make sure they're signed. I talked about earlier, signing the document in the name of the entity rather than the individual. That's always important to keep in mind. And then also keeping in mind the dangers of complexity. If the contract is too complex or there's too much going on, it might be hard for you to understand, hard for the other party to understand. If it, for whatever reason, went to court, it might be hard for the court to understand. So where you can keep it simple and straightforward, that's definitely the best move. And kind of related, the next 2 points I think are kind of related in my mind too. You want to keep an eye out for anything that is going to limit your future flexibility or might have unintended consequences. So anything that might restrict your business in some way, you want to kind of like keep an eye out, flag that in your mind. And there's some times where you might need to seek professional legal help if you don't understand what this restriction is going to do for you down the line or what it means. You might want to seek professional legal help because you're signing this contract and it might restrict you in some way that you didn't realize. And we've said this before as well, but be wary of contracts found online. You don't want to download a contract that's all about Delaware law or Idaho law if you're in California doing business in California. You want to make sure, go through if you do get a contract online and kind of just spot check it, sense check it, make sure everything makes sense and that you understand everything. And it makes sense that it's from California, stuff like that. And paying attention to the details, kind of going back to my chicken example, vague language might remain up to interpretation. So you want to keep vague language to a minimum. Next slide.
Sure. I had one quick question, I think, relating to this slide. And Stacey Radcliffe asked, as a member manager, can she sign an agreement like on behalf of the business, or do you sign the business name specifically?
Yeah, that's a great question. Essentially, well, first, is it a single member or a multi-member? I guess it really doesn't matter, but it does for the signature block, right? So if it's like a single manager, you're the sole manager. So you would sign as like the company, like just literally typed out the name of the company or written out, and then by, and then your name, the person's name, and then title, sole manager or managing member or member, depending on the flow of the LLC.
Totally. So you'll sign your name, but it would be the business, you know, as a member of the business.
And if you have an LLC with like, you know, officers or other types of folk that like are part of your employees or senior employees, you can by resolution give them authority to sign contracts, right? But that's a double-edged sword. And in that case, you know, they would sign in their capacity as that like LLC's name by that person's name, their title, you know, secretary or vice president, etc.
Okay, and then just some general things that are specific to California. Restrictive covenants are generally not enforceable, and what a restrictive covenant is, or a common example of it is a non-compete. So if you have employees or, you know, someone that works for you sign an agreement that says they won't work for a competing business or, you know, similar businesses in the state of California or something like that, that's generally not going to be enforceable. Parties have significant freedom to draft broad indemnity clauses. We've talked about indemnity clauses. It means, you know, again, it means agreeing to pay for somebody's losses or liability that comes out of the contract, and they can be particularly broad in California. So you want to read them and read these clauses and make sure you understand, you know, what you're covering, what you're agreeing to. There's an implied covenant of good faith and fair dealing in every contract, which is kind of like some examples of not doing that would be taking advantage of somebody or intending to mislead someone, or, you know, something they don't, and you kind of mislead them in some way. So you want to each party should just kind of, you know, not do anything that will deprive the other party of the benefits of the contract. And then there's a 7-year rule for personal service employment contracts. They're limited to 7 years. And next slide. And so now we'll open it up for questions.
Does anyone have any questions in addition to what was in the chat already? I think, oh, are there any specific agreements that govern healthcare is a question. There are, I'll just add, there are specific laws that govern contracts or the healthcare industry and companies that do work in healthcare. And there are definitely provisions that you may want to include in those contracts, but I think that would be kind of a very particularized question that if you are interested in learning more about that, we can try to find like a specific attorney with experience in healthcare to help answer those questions to the extent you're eligible. I don't know if anyone on the panel out of all of you have any specific experience in healthcare that has additional insight, but this is definitely one of the more particular, like specific areas.
Yeah, I'll agree with Matt. Healthcare as a whole is a very heavily regulated industry with a lot of regulations and laws, so it's definitely a specialized area.
Yeah, definitely. And there's laws that apply if you're delivering healthcare versus whether you are providing a service that is adjacent to healthcare, that is near healthcare, supporting healthcare. So there's a lot of things that you'd want to think about. So we can try to work on that separate from this. Any other questions? Well, thank you all for being here. I think Kayla just, perfect. Kayla just put into the chat our application links if you're interested in applying for our one-on-one consultation sessions, either next week or just generally on contract or other topics. Please fill those out, and then Kayla and or I will reach out to you. If anyone has any other questions at a later time, you will all be getting an email from me or Kayla. So you'll be able to reach out to us if you have questions. We will send an email with the recording of this webinar. Oh, great, Stacey, I'm glad. I think, yeah, we will be in touch then with you. Please feel free to reach out if you have any further questions. Oh, it looks like Nathan has a question. I think are you writing it, Nathan, or? Oh, okay, there's a couple questions actually. First, what is good to know for a performance contractor that is commissioned only? So this would be a contractor that you're just paying based on commission. I think, I think it's a very broad question. We could talk about that. I think Nathan, more specifically, one thing that might be helpful is if you were to set up an individual meeting. But I don't know if the panel has any thoughts on performance contracts that are based on just commission.
That's pretty difficult to answer without knowing more of the facts, but from the perspective of the service provider, if it's commission based, I want to set up certain metrics so that it's not all or nothing. That's kind of a general thing, right? So you want to hit each individual metric, and that might trigger a performance fee or like a payment fee. But otherwise, we'd want to know more details before providing more advice.
Totally. In general, for contracts like this, you'd want to lay out specifically what the contractor is going to do. Like what Jesse said, you want to have specific metrics, and you want to have specific language just setting forth how the payment will be made, you know, how much, if they meet certain metrics. You just want to make the payment terms and what they're going to do clear. But it is definitely where we'd want probably more information about in order to do that. So Nathan, we can connect if you have like more particularized questions. There's another question from Joe Vega. What is involved in a letter of intent to perform work? I guess, is that a contract in of itself? What is a letter of intent? That is the question.
So generally, for a letter of intent can be as you know, as much of a contract as you want or don't want. We typically advise that the letter of intent be a kind of a looser agreement between the parties to enter into negotiations, so that folks understand that, okay, like, you know, we're both sides are coming to the table and we're going to start like forming this contract. And I did mention earlier that we see, you know, that letters of intent can be more contract based, but for the most part, we see them as more of an agreement between two parties to just start negotiating with the goal of doing something. They're pretty informal, so that's what we typically see.
Yeah, and one thing I would add with letters of intent, like they're not necessarily the full-blown contract. It's usually a precursor that we agree to negotiate, but there is oftentimes an agreement to negotiate. So if you enter into letters of intent and you really have no interest in negotiating, or you don't do any sort of good faith negotiations, then that could be something that could be considered a breach of a letter of intent, depending on how it's written and everything. So it's something to keep in mind if you're entering into letters of intent. While it's not the full contract, there may be obligations related to it.
Right, and actually bouncing off of that, Matt, I suppose if you're going to be party of a letter of intent and you're not sure of the other party's intentions, maybe set an expiration date by which, you know, if some agreement hasn't been negotiated by this time, both parties are released from that letter of intent.
That's a very good point. You always want to be very clear for these types of letters and contracts in general about how long the contract will last, to make sure that you're not entering into contracts for longer periods of time than you want. And Stacy, we'll contact you, Stacy, in response to your chat question about find someone. If we are able to find someone to help you, we'll contact you. You do not need to set up another appointment. All right. Any other questions? Thank you for all the questions. This is great, and thank you for all of the feedback and responses to our attorneys here. All right, I think then that will be it. If anyone has any further questions, as I mentioned, we will be sending out the recorded version of this webinar by email. So you will have our email address in the next couple of days once the recording is ready. So if you have further questions, please let us know. If it's something that we're able to answer, we will. If it's something where we think that it might be helpful to set you up with an appointment with an attorney, if you're eligible, then we'll work on doing that as well. With that, does anyone at Simpson Thacher have any final words? Want to say anything?
I think we're good here. I mean, generally speaking, again, with contracts, like they can get complicated and they will get complicated, but at the heart, make sure you understand everything, and to the extent possible, keep it as simple as you can. Really.
Definitely.
And we appreciate, of course, you giving us the opportunity to talk to the group and to work with Inland County Legal Services. And I think we'll see, hopefully, some of you folk next week during our clinic.
Yeah. Well, thank you so much. We appreciate working with you. We appreciate your time. Yeah, there's thank yous going into the chat. I don't know if you're seeing that. But I think that will be it. Again, everyone reach out to us if you have further questions. We are available to help.